So sorry about the timing problems. Basically, we are at fault. Nobody else is at fault. So sorry about that. So welcome to today's faculty forum. So we're really pleased to have Moeen and Sadaf's paper out for discussion. It's a great paper which provides a lot of food for thought. So I'm sure our discussants um, will provoke a lot of conversation as well. So before I turn it over to them, I'll just say a couple of things by way of housekeeping and introduction. So just before this session started, we had a quick call with the conveners who I'll just introduce. So we have Pavni from Colombo, Swati Singh Parmar from Jabalpur, and Animesh from Kolkata. And the discussion we're having is about the faculty forum going forward, and who's presenting, who will be who will be populating the schedule going forward. So something we've just decided on. Sorry, I have to apologize for being so uneloquent at the moment. All your faces keep shuffling about on my screen. So I'm not going to look at you for a while to stop being distracted. So we're basically extending the eligibility criteria for who can present a paper at the forum to any early career scholars or practitioners or academics who are writing on South Asia and not necessarily needing for them to be based at a South Asian institution or teaching at a South Asian institution. So we'll be putting that up by way of social media, but we just want to also let you know, because word of mouth is something that we've also been utilizing to advertise the forum. So that's just to let you know about a little bit of a change with the forum, because it is a fantastic forum for workshopping papers and works in progress. I've been a discussant at an earlier forum, and I know I benefited a lot from just hearing from other discussants and looking at work more closely that's at a very early stage of development. So I think it's a fantastic forum for everyone to kind of get involved in any form, whether to present a paper or as a discussant. So before I hand over to our discussants, I just want to say that if you're not speaking, it would be quite helpful to go on mute, just so that whoever is speaking, their connection doesn't break. Yeah, thank you. So we've got two discussants today. We've got Surabhi Chopra from the Faculty of Law of the Chinese University of Hong Kong, and we've got Arudra from IIT in Delhi. Am I right, Arudra? Yeah, and so we'll be handing over to them to give their comments to the authors, Sadaf and Moeen. Sadaf and Moeen, after they've given their comments, I'll hand over to you for a couple of minutes to just give your reactions to those comments. It's not obligatory to do so, but if you wanted to just react to some of those comments, you're most welcome to do so. And then I'll open up to the floor. I also have a lot of comments, but I'll kind of hold off until the discussants and yourselves have had a chance to speak. So Surabhi, would you like to go first? Yeah, thanks.
Sure. Thank you, Swati. Moeen and Sadaf, I loved the paper. I thought it was just very impressive, just the depth and the breadth of reading, the sort of the depth of knowledge around the case law, the way it had all been processed, the historical sweep of it, the time period you covered. Very, very impressive. And I was trying to think, have I read anything that touches on preventive detention jurisprudence in Pakistan to anywhere near this level of depth? I've read Imtiaz Omar's book and Nasser Hussain's work, and really, I think has come close to, I mean, their work isn't squarely about preventive detention, but this really is a contribution, I think, to the South Asian scholarship. So really, really wonderful, skillful chronological account of the development of preventive detention jurisprudence in Pakistan. And so I actually struggled to, think of what feedback to give, because it is already, I think, such a well-presented, sort of fluently written, well-structured paper. Um, one, I think my first reaction as a reader, as I went through it, was it is very dense. For someone who doesn't know the South Asian context, I mean, my own research in the past has been on national security jurisprudence in India. And as a result of that, I'm reasonably familiar with some of the comparative jurisprudence from South Asia. And even I found it quite dense. So I think for someone who isn't as situated and grounded in this specific topic, it is very tightly packed. And so just stylistically, structurally, I was wondering, are there ways to let it breathe a little, to sort of leaven the reader's experience and allow, I think, for a little bit more absorption of, because it's such a whistle stop tour, and you're, I think partly because you're covering such a long stretch of time. Related to that, I did think it read a little bit as if it is a very interesting doctrinal discussion of jurisprudence on preventive detention, and then towards the end, the most recent or latest phase of jurisprudence you discuss is on disappearances. I thought it read a bit like it read like a doctrinal analysis sandwiched between a little bit of theorizing. And I think it would be nice to see it develop into a draft where either it's a purely doctrinal piece, and I think it would be a very strong, very solid and interesting doctrinal piece, where I'm not sure we need the sort of gesturing to, authoritarian legality, etc. Or I thought one way to let it breathe a little is to let it get a bit longer and weave in more thoroughly into every phase of jurisprudence you discuss. The theorizing on authoritarian rule of law and authoritarian legality that you start out mentioning and then circle back to at the end. I felt like it wasn't quite embedded enough in your analysis as it proceeds through the body of the paper. I'm just looking at my notes. One thought I had is, to me, the narrative that you put forward is one of, incremental, 2 steps forward, 1 step back, judicial nudging of the executive branch, of the military as well, and often for long periods of time, primarily the military, right? And then when we come to the Musharraf era, where it's an authoritarian government, but of a different character from past authoritarian regimes in Pakistan. It is a more open authoritarian regime, considerably more freedom of the press, more rights protection, stronger courts. We see a sort of rupture in authoritarian rule of law and authoritarian legality, and a turn to kind of a purer extra legality. Right. And that's a very interesting kind of coda or kind of twist in the tale, a very sort of dispiriting and bleak twist in the tale, but also a very interesting one. And to me, it was it's a very interesting counterpoint to the literature that's developing on autocratic legalism. The starting point, the introductory paragraph of a lot of the recent writing we've seen on autocratic legalism, democratic backsliding, constitutional decay, what have you, is the toolkit of the neo-authoritarian tyrant is different from the toolkit of the mid-20th century tyrant. The neo-authoritarian tyrant, the present-day populist, within an electoral democracies or a more purely authoritarian government today, doesn't turn to show trials and executions and the kind of performative, dramatic illegality. It's much more nuanced. And actually, I think the story that you tell about Pakistan on this particular issue is sort of a reversal of that, right? It is, we see legality as a very important tool for military authoritarian regimes over the course of decades, right? And quite legalistic ways to counter the court's attempts to ameliorate the excesses of how preventive detention is used. And then when we actually have more robust rights protection at a constitutional level, we have a more assertive court, we see that rupture into, picking people up and disappearing them. So to me, this doesn't fit with the narrative around what is happening right now in the world. And I wondered if that, does that resonate with your thinking? Because that's what jumped out at me. The last thing I'll say, and then I'll hand over to Arudra. I know I'm taking up quite a lot of time. You make the argument that the judiciary through these decades has served in various ways as a limited incremental check. And I wasn't entirely persuaded by that argument, because it seemed to me that the judiciary, one, was very hesitant, understandably so, I think, at various points. But also it seemed to me that it was repeatedly checkmated during the Ayub era, during the Zia-ul Haq era. Surprisingly, and I didn't know this, during the Bhutto regime as well. And so again, I'm not sure, I was not entirely persuaded by your overarching narrative of the judiciary's role and the, if I can, put it slightly naively, the good the judiciary managed to do. And I think one way perhaps to make your narrative come through more convincingly is in that kind of making this piece breathe a little bit more for every era. Perhaps we need a little bit more political context and grounding. You already have quite a lot in there, I think, especially in the last section, the Musharraf era, talking about war on terror, etc. But I think some of the earlier sections, we need a little bit more for the non-South Asian reader, or, reader who is not aware of the Pakistani context and the South Asian context more broadly. But on the whole, just I think it's a wonderful piece, and I'm looking forward to reading, the final draft.
Thanks, Surabhi. That was really, really, a lot of your comments actually resonate with some things I was thinking. So depending on how the discussion goes, I might pick up on a couple of threads that you've highlighted. Arudra, I'll hand over to you.
Great, thanks, Swati, and also thanks to Sadaf and Moeen for this paper, which I also enjoyed a lot. It's interesting to go after Surabhi because in some senses, there are things that comments I have, I think, echo what she said, but in other respects, I think I reacted quite differently from the paper to the paper than she did. So what I'll do is, and am I speaking too fast? You can hear me? Okay. Yeah. Okay. What I'll do is I'll just raise point to two questions or maybe lines of inquiry which the paper opened up for me. And I thought, if you did want to leave in the paper, to use Surabhi's term, which I think would be a good idea, these at least would be two questions that the material certainly spoke to me, and partly because of my own particular interests. And then I'll say I have a couple of points which are more by way of comment and criticism about the structure of the paper and the argument, which in some ways also echoes Surabhi's point. So on to the first question. I read the material quite differently from Surabhi did. And I thought, look, and maybe from the way, in fact, you guys seem to present it yourselves, I thought, I left thinking, wow, Pakistani courts have actually done a pretty good job of standing up to the executive in when it comes to preventive detention. They've they've gone against particular executive decisions. They've fought for jurisdiction. They've changed levels of scrutiny from purely procedural to substantive. The main complaints. So of course they've been checkmated at various times, but they may not have much choice about that. The main complaint is that at least in some high-profile cases, like the Mujibur Rahman trial, they haven't been able to step up. But overall, in a period that is a basically authoritarian constitution set up right from the start, and that's actually one thing that struck me was your periodization, at least 9 different periods of constitutional change in the time period that you're talking about, all of which are authoritarian in one way or the other. For the courts to have managed to do this, if I'm reading your material correctly, that's pretty cool. And I think for me, it opened up the question of, well, what made it possible? Is there a story of actually constitutional resilience to be told here? And, are there aspects of ideology or practice or, maybe politics more generally that that make that possible? I mean, for the courts to really to get by even things like this, the 1981 Provisional Constitutional Order, judicial purges, I did get that sense, and you present that in this very cautious kind of, they had this limited kind of role, but for a common law court to be exercising habeas corpus in this period, it wasn't clear to me what more they could have done. Maybe there. So that leads to the second question, which is really about the jurisprudence of these cases. And one of the things that I would have wished for, that I found myself asking, is wanting to know a little bit about what the jurisprudence was and what is the way it's being unfolded. I mean, it seems pretty clear from what you do say that it is a kind of, it's a habeas corpus sort of jurisprudence, rule of law principles, procedural formalities, and so forth. One question I had is, for instance, does the jurisprudence have an internal periodization of structure? That right now the paper is structured in these regimes where there's an external political change, and you speak towards the end, well, as the Chaudhary court, but are there other courts in between where you can see, look, there was this period of time when the courts were doing X, and then that changed. And did that change? Are there landmark cases? Is any of this contested? So I would have, I'd have loved to know more about that. What is the emotional tone of these cases? Are these cases sort of standing up for these principles? Or, I've been reading a lot of Indian cases on preventive detention from the 1940s. And it's interesting to see at what stage, does it even matter if you're doing this kind of work as a judge, whether you're, introducing a lot of judicial rhetoric into the picture, or are you just saying, we've decided to construe the statute strictly, this thing was not met, the person has to be released immediately. So I'm just curious as to what the maybe the judicial rhetoric was. And I'm particularly curious, actually, and again, that's partly a function of my own interests, as to what sorts of intellectual resources are these courts drawing upon? Intellectual, normative, moral resources. Are they saying, we are courts of the common law that have this historical function? Are we saying we have a particular role in the context of an authoritarian regime? So where is, if as seems likely that they are drawing upon rule of law principles, where are they locating the normative basis of those principles? And I've been thinking about this in the context of in the Indian case, which I can talk about more. So those are the two sets of questions that your piece made me want to sort of find out more about. I'm not saying you need to answer them, but maybe if you did want to expand the paper, these are directions that I certainly would find exciting. Now, let me move to two things which are not so many, well, I could frame as questions, but really they're comments about the broader argumentative frame. And I think I share Surabhi's thought that she didn't present it quite as, but the introduction and conclusion and what you seem to say, or you want to say by means of the cases, I thought I wasn't so convinced about that. One is the towards the end of the paper, you want to say, look, you're reading this trajectory as revealing limitations of the liberal rule of law, and the way you present it is as though this is a kind of a criticism of this ideal or the way it's practiced. But I mean, I wonder whether any, that even the court, once it gets powerful, can't, it can't deal with these people who are being made to disappear by the military. And I just wondered, sure, of course, this shows that there are limitations to the effective protection of individual liberty through the court. But who would deny that? And who, even the strongest believer in the rule of law, presumably would accept, yes, that in fact, there comes a point, whatever the best court is not going to be able to protect against the most, despotic rule or whatever. And in fact, you might see this, look, these guys did as, they did what they could, and it's a sign of their success. Maybe it's a sign of their success that now, the security forces have to dispense with all legality altogether and pick people off and make them disappear. So you might see that actually as something that's a point in favor of somebody who believes in the rule of law. Particularly, I think, in the context of these very different constitutional regimes that the courts seem to have been involved in. So that is one comment about this frame. In your abstract also, the history of judicial review highlights that liberal rule of law is at best a contingent means of protecting citizens' liberty. I was thinking, if I gave I don't know if this is a good analogy, but I think if I was a military historian writing the history of some cavalry regiment, and I might say, look, these horses were great and they did this job, but then the tanks came and then they couldn't do anything about the tanks. Sure, does that mean they were not good as horses? No, that just means that they're just outgunned. So I wonder whether that's the rule of law person might say, yes, you've actually confirmed my point. And the last comment was this point about the Nasser Hussain kind of appeal. I found unconvincing. No, my understanding of it is of that mode of talking about habeas corpus and things is, yes, it can be used to legitimize imperial and repressive legal orders, because you say, look, you have this, it's essentially an authoritarian system, but look, it is leavened by this commitment to the rule of law, and that might be a fig leaf of some kind. If that's what was going on, you would have to show not what you've shown, but you'd have to show that the executive and the authorities are saying, hey, things are not so bad here. We have these well-functioning courts. In my understanding, at least, the Nasser Hussain kind of picture is all about justifying your regime by appeal to the ideal of the rule of law. And to say that this illuminates your case, you'd have to show that the regimes in question were justifying their repression on the basis of their ideals. You don't have that material. I would offer the possibility that, in fact, the situation might be quite different. Right? Maybe this is not a case where, I'm just looking at your last sentence in your paper. One of the maneuvers of an ideology of a rule of law itself is to portray instances of emergency and the powers deployed to confront it as episodic and interruptive. The promise of liberal rule of law often legitimizes, or at least renders palatable, an authoritarian legality, while also normalizing the everyday pathologies of the law. I mean, I didn't see any of that actually in the context of the material you were talking about. Not to say it's not there, but portray instances of emergency and the powers deployed as episodic and interruptive. The Pakistan case doesn't seem to be like that, right? It seems like, in fact, that's the, that's the base. But yeah, so I'll stop there. Right? Yeah, and like as with Surabhi, I really enjoyed the paper, and I hope to engage with this material in the future as well. And yeah, and thank you Swati and JFF for inviting me. So I'll stop.
Thanks so much, Arudra. So thanks, Surabhi and Arudra, for all of your comments. I'm sure Sadaf and Moeen, would you like 2 minutes to just react to them, or would you like to just go straight to the floor?
Sorry. Moeen,
yeah. So do you want me to relieve you of some of the burden?
Some of the burden.
Some of the burden. By taking responsibility for some of the comments that some of the comments that are my fault. So
yeah,
the whole flirtation with the rule of law, and that came through in both of your comments. Like trying to theorize something within the space of the rule of law is principally my fault. Yes, Sadaf, you would agree to that, right? Okay.
Yeah, I mean,
nice.
so,
yes.
No, sorry, I had to quickly. Well, it's a. I don't know whether this is going to be very good for the people who are assembled here, for us to keep passing between each other, passing the buck. But yeah, no, I mean, but please go on, Moeen. And then I would like to address some of the, comments that were made, which I found really instructive and useful. But go ahead, Moeen.
So essentially it's so I'll just deal with that bit. Because that's something that I recognized over for many years, did quite a bit of work on rule of law theory. And Arudra, your point is very well taken, because that's what Joseph Raz basically said. That's what formalist, liberal, rule of law theorists essentially say. Rule of law, Joseph Raz was like really upfront about it. It's a limited good. Rule of law is only good. It's not a universal good. Rule of law is only to basically, if I'm accurately paraphrasing him, undo or try to minimize the harm that law itself can do. Right? It's not there to solve every problem under the sun, which is a lot of people, and especially people like us who've gone through like the heyday of the lawyers movement and the Chaudhry court, and there was a lot of talk about rule of law in Pakistan, so maybe there's a bit of a hangover of that. And essentially that's what we, or at least I was trying to push back at, and basically saying there is value to, there's value to rule of law, formal rule of law, there's value to legality, which is what these courts keep telling us again and again, but it's a limited value and there's limited utility, because that's all you can hope to achieve, is minimize the harm that law itself can do. But I think we started off with which is where I'll hand over to Sadaf. We started off with this paper from the other end, looking at the phenomenon of missing persons and enforced disappearances, and why does the state, and in particular the military, have in recent times adopted that as the front and center of the technology of repression, for lack of a better way of saying it, whereas the state has already historically, so when we go back, has multiple technologies, multiple means, whether it's sedition, whether it's enforced disappearances, whether it's state security laws, whether it's anti-terrorism laws in the 1990s. So why this and why now? I think that's the question that we started off with. And in many ways, the answer was, yes, some of the stuff that is happening now may be new. I think to some extent, maybe, in response to Surabhi's one of the comments, maybe some of this is new and this is interesting as to, why this is happening now and why is this happening in this particular form. But there's a much longer history, and there has been this bedrock this kind of dialectic between the state and the judiciary about multiple forms of this particular phenomenon. Can I hand over to you, Sadaf, now?
Sure, thank you. Thank you, both of you. And thank you also for the invitation. I suppose we were late, so we didn't get to do a kind of preliminaries, but thank you so much for allowing us to workshop this paper with everybody here. It's really instructive, and I'll sort of explain. So, I mean, just off the bat, Surabhi, so am I saying your name correctly? Yes, thank you so much. And I completely agree. And so I was reading this just, you know, in anticipation of this workshop and thinking precisely that it doesn't breathe, where like one has to leave those kind of pockets. But actually, and in a way, I suppose this is, you know, why it's really useful to workshop this as well, is to figure out what those spaces would be, because I think we are starting with doing something that in the Pakistani context doesn't exist. So not only with preventive detention, not only even with the missing persons cases, but even just generally, we don't have too many compilations charting national security laws and their impact and, you know, histories of judicial review. So there is a lot that gets thrown in there because, like Moeen was saying, you know, if we're starting with this period of, you know, sort of 2004 onwards, where you have missing persons, and that's really, it's a kind of history of the present, you know, charted out vis-a-vis these kind of preceding technologies, which obviously have a very, very long historical lineage woven through, you know, colonialism and then post-colonial state consolidation and, you know, constitution making, whatever the case might be. All these technologies shift and change, you know, in reference to obviously, you know, self-evident ways, those larger political configurations that are unfolding. So I think that's absolutely true, and that's why it's useful, is because, and I think we're situated in different populations of cases and case understanding and trying to kind of piece together that historicity. And I think, and I'm going to merge some of, you know, or address together some of the things that were said. So I think that the kind of view that there might be a judicial periodization is something that would be really quite useful, I think, to be woven through this. And I think also it's indicative for us, and Moeen may or may not agree, is that I think we do see different periods, right, of what is kind of a pushback against, you know, the executive powers in one way or the other, as, you know, from 1947 onwards. So there are earlier episodes where it is just making recourse to the fact. So it's, you know, it's interjections of just sheer, you know, the existence or not of a constitutional document, right? And the things that it makes available. It's, you know, the existence or not of electoral exercises and statutory enactments that allow for electoral exercises. It's things like that, right? Which make available for judges at various periods certain types of tools and vocabularies that they can rely upon in order to push back, right? So much of what happens in the Ayub era is in reference to the kind of managed democracy that Ayub himself was consolidating, which allows, right, a certain amount of percolation through of certain types of guarantees for electoral exercises and the like. So the kinds of pushback against preventive detention particularly they exist in kind of interplay with the kinds of pushbacks against larger bands of political parties and the like, right? And sort of tests that are forged at that point, whether those are objective tests, thereby reducing, you know, the scope action or things of that sort. It changes markedly then, you know, post-AU, post-Bangladesh, post the enactment of the 1973 constitution, because a whole new set of considerations are thereafter being utilized by the courts, right? So you have a democratically, consensually based constitution was enacted in 1973. So even in the period, so you see different kinds of maneuvers, you see different kinds of executive maneuvers as well as broadly governmental maneuvers being used to control the judiciary in that period. So right after 1973, you have a succession of constitutional amendments, which are basically aimed at kind of destabilizing the judiciary, right? So they're about, removing guarantees of tenure and the like, making things that were already agreed to within the constitutional document thereafter unavailable for the judges in terms of standards or levels of that they can apply to the preventive detention regime, right? So the kind of turnings are quite marked. In the 1990s, you see a great many other things, right? And I think in a way, I think we have made recourse. So, I mean, I think Moeen has taken a lot of, he's taken that on himself, but there is a way in which in prolonged episodes of electoral democracy, and by prolonged episodes, I mean 2 successive or 3 successive elections without a military coup intervening directly in the middle. I mean, you have all sorts of other executive suspensions and dissolutions of assemblies happening of the 1990s. But what you also see is that actually the kind of review that the courts start to undertake becomes much more thoroughgoing. So they do engage in looking at the purposes of these existing national security laws, right? What are the aims? What are the purposes? What are levels of, risk or suspicion for which, the state can utilize these tools of preventive detention? You have all sorts of other things happening in that period, which they hadn't been doing prior to that, right? So you actually have the expanse of judicial review really broadens up to and leading up to ultimately this kind of, post 2001. So with the waging of the international war on terror, what happens in Pakistan is a different thing. I mean, that's a really major thing that, you touched upon. Okay, what is the nature of this kind of new authoritarianism, right? And Moeen sort of indicated, right, that for those situated in Pakistan, yeah, I mean, so some of it is this confluence of things. And I think that that's actually where, a great deal more work has to be done, by us, because it speaks in various idioms, right? This authoritarianism. So like you suggested, obviously there is a great deal of media liberalization that happens in the earlier years of the Musharraf regime. There is indirect democracy, again, instituted, right? But you have the other measures also in play. And then you have the backbone of this authoritarianism being that, Pakistan comes within this kind of global security imperium fighting on a particular side. And the tools that are there, or the kind of technologies that are thereby allowed to be utilized, right, within Pakistan with the unfolding of the renditions regime, all of these other things, of Guantanamo Bay, preventive detention on a kind of, or just, disappearance on a global scale. And it's also not a simple statutory enactment. So there's a way in which the presumption that these things, can go on under the cover of other kinds of development goals being met, right, for the Pakistani populace. So other vestiges of liberalism being implanted throughout society, and developmentalism. And so, picking up the few bad apples who are obviously cast as aberrant creatures, whether because of their radical Islamism or because they're, members of ethno-nationalist groups and the like, how do we justify that is something that happens and unfolds in various stages, even over the course of that sort of decade and a half. And there's no simple story to be told about it, because it does happen very much in the dark of the night, happens in some ways seems a reaction to the vigilance of courts to actually investigate it and not take the justification of national security as the legitimating reason for, preventive detention to be exercised against some of these people that are being held, but then goes through a whole other transformation whereby there is a whole regime of statutory enactments that are put in place, which again is something that is happening globally, right? So we have something called the Pakistan Protection Act. We also have some notorious and horrifying piece of legislation called the Actions in Aid of Civil Society.
Sorry, Sadaf? Sadaf?
No, what is...
Sorry, Sadaf, this is Swati.
Yes.
So if I could just pause you there.
Am I going on too long? I'm actually not that familiar with the format, so please just cut me off.
No, I feel bad doing this in the context of a paper looking at authoritarianism, but just in the interest of really...
You can't hear me?
No, just to grab more feedback from the floor. Could I pause you there, go to the floor, and then we can always come back and continue this?
Sure.
Yeah. Okay, so I've got myself and Tarun on the question list. If anyone else would like to ask a question, just raise your hand and I'll come to you. So Tarun, I'll go to you first.
Sure, thanks very much, Swati. And I should also apologize on the behalf of the organizers for messing up many things, including the timing, but not just the timing. We also didn't brief the authors about our format, which is that, we don't, so you didn't miss anything because we don't have a presentation at the start anyway. We just assume that the paper is read and people are not allowed to attend unless they have read the paper. So we start with discussants, and so there were no niceties, and we don't have niceties. We just dive straight in, and we try to keep sort of author time actually quite minimal, a couple of minutes, because the hope is but that's also our fault and not yours, because you've not been to this forum before. But I hope that you will encourage your colleagues and also become a regular, encourage your colleagues to join the forum, because the aim is to give as much feedback as possible to authors in a collegiate, kind but robust environment. So so thank you very much for this paper, and I completely agree with our discussants. It's a fantastic paper, and I learned a lot. So so obviously I'm not going to talk about what's good in the paper, because we could be here for a while. I'll just focus on what could be even better, and some of that has already been picked up. But actually, one pushback to Surabhi's comment on audience, I discussed in Surabhi. So Surabhi's comment on audience, I actually thought, so this is a burden that every paper written outside the canon, right, which is basically outside the US, but maybe sometimes outside the UK and Germany, has to bear, which is how much analysis do you do if you're writing for an audience that's not necessarily that's not just a domestic audience, and how much description do you do, right? Because you can't just launch into analysis because the background is not well known, right? So I actually thought that you strike the balance quite well in this paper, and that there is a sort of inevitably a grand narrative of Pakistani history, into which Pakistani political history, into which you weave the various arguments. So so I wasn't sure that you actually could do a lot more and still keep the paper to around the 10,000 word size for a journal, and not lose some of the analysis. So I actually thought that if I got Surabhi right, then that was probably fine, I thought. But the two things I want to push back on, one is something that Arudra has already picked up on the rule of law, and and Moeen, you know the two papers by Raz, which are sort of the locus classicus on the rule of law, but I've just posted them here. The two different links for others. But I just think that this just felt like beating a straw man in the paper. A, you don't need it, right? And B, if you're doing it, you have to engage with what the other side is actually saying, because otherwise it just felt like you're throwing a stone and running away at a straw man who cannot fight back. And this is in a lot of post-colonial literature. liberalism, rule of law is also often invoked as this straw man, often beaten up, but without any argumentation, which leaves you feeling, okay, so what is the problem here? So one way of reading the paper is that Pakistan is not respecting the rule of law that it should, right? So, when you talk about the state has carved out a near complete impunity, this is page 2 towards the end, right? That sounds like a clear breach of the rule of law. So first, it's not clear what you mean by the rule of law, because at some points the paper reads like what you think rule of law means is judicial review, right? Now, no serious scholar of rule of law actually thinks that rule of law simply means judicial review, because judges can violate the rule of law and judicial review can be incompatible with the rule of law. And then there is the horse and tank analogy that Arudra gave. My analogy was that, if a government proposes a policy to achieve equality and the policy is either defective or badly implemented, that does not make equality a bad ideal, right? So some of the attacks on rule of law felt like, oh, it hasn't been achieved, but that's not a problem with rule of law, but the failure to achieve it. A third problem, which is implicit in this paper, but very widespread, and this is the targeting of liberalism as well, which is, oh, racists and authoritarians and imperialists liked some of them liked liberalism, right? But racists also liked feminism, right? And they also liked communism. So that is attacking sort of ad hominem attacks on ideas, right? So it just felt unscholarly when you're not dealing with the best version of the rule of law, which I think, RAS produces, as you acknowledge, it's not the only thing we care about. It should sometimes give way to other things. And the world will not be perfect if it has institutions that abide by the rule of law, but there'll be something good about them, right? So the second critique, that Masood's critique that you notice, that actually, so you say limiting arbitrary power and promoting injustice are not always mutually exclusive acts. That is absolutely true. Right? But again, that is only a critique of the rule of law if the rule of law claims to be a bulwark against authoritarianism of all sorts. But it doesn't, right? As you say, as the scholars of rule of law will be the first to admit that it solves some problems, but not all the problems of the world. So I just thought that, either give up, and this is not a paper on the rule of law. I think it's distracting to actually talk about the rule of law without, if you want to criticize it, have a full section where you engage with actual arguments of the best best foil, right? You have to not beat straw men. So that was my sort of thought on the rule of law. And the legitimizing function, which is that, a regime can pluck a low-hanging fruit and use that to legitimize itself, that's more complicated. Right? And that could be a contingent critique in certain contexts. But I agree with Arudra that you don't actually make that point, or at least the burden of evidence is not discharged. But also we have to be careful about how that critique is made, right? So I'm imagining a murderer who is terribly honest, right? Who will, so, assuming value pluralism, just as there are multiple goods that people can have, there are multiple goods that states can have, multiple virtues, and a murderer can be terribly honest, right? So if their honesty is used to justify their being a good person and ignore their murder, that can be a problem, that would be a problem, but you have to show that that's actually what's going on, and that is that a problem with the rule of law or not? The final thought I have, and this is just a reference, which is that I think a much better framing for your argument is a recent book by Yvonne Tew, which I don't know if you've seen or not. It's called Constitutional Statecraft in Asian Courts. And she mainly looks at Malaysia and Singapore to do precisely what you're doing, I think, which is to show how in extremely difficult and authoritarian contexts, some courts are acting as strategic political players to to incrementally carve out a space for themselves. They're not fighting all battles because they can't and they will lose, but they're picking their battles carefully and fighting those battles to continue to ensure that the courts are not shut down and they continue to exist and do some good, right? So I thought that that was a much more interesting framing for this paper than the rule of law. But it's a great paper, really well written. I thought very well structured, and I finally, wearing my selfish editor's hat, I do hope that you will consider the ILR in terms of where to send it. But I'll shut up there. Thank you very much.
Thanks so much, Darren. So I have Matthew is on the list.
Yeah, hi. I believe it's a wonderful paper, and I learned a lot by reading this paper. I just have one comment. I believe that it will be more reader friendly if you are giving subheadings also in the article. I'm not sure whether it's an opposite comment, but yeah, I just wanted to offer that comment. That's all.
Thank you. Okay, so I'm gonna use my chair position to ask my questions or give my comments. So yeah, great paper. I learned a lot from it. So preventative detention, forced disappearance is not really my area, but a lot of what you say about the role of the courts resonates with work that I do. So I want to echo everything Tarun said about the rule of law as a framing device. I feel like it's definitely more of a distraction than it is an enabling tool to help you to do the argumentative work that you would like to do, especially because early on in the paper, you set up this contradiction that you then play with throughout the paper. So the contradiction of the rule of law, and also the rule of law is something which restricts executive reach, but also restricts liberty. And when playing around with that contradiction, it's very clear that you've got a very specific idea of the rule of law in mind to set up that contradiction. So, and then there isn't much done with that contradiction, but there are so many questions that are left in the reader's mind with respect to it. So I wonder whether rule of law is the right frame to use. So I just want to start by echoing all of the comments made on the rule of law. My comments relate more on the construction of your paper and the objectives of your paper. So as I read your paper, I thought there were three really interesting threads or stories that come out in your paper. So the first is sort of the periodization of preventative detention laws, legislation, moving from era to era. That in itself is a really interesting story to look at. So what have been the legislative amendments? What have been the legislative introductions? How have the laws changed over? And then also looking at sort of constitutional changes as a counterwave to all of the anti-liberty laws, if I can group them together. So that's one thread that I see. The second thread that I see is the historical case that you make. So early on in the paper, you talk about the colonial legacy and the impact of the colonial legacy. So there's this whole historical argument that's being made. The third one, and this is the one that I'm the most interested in with respect to your paper, and that's really the courts, the position of the courts. So here I really agree with what Surabhi and Arudra have said, that for me, the discussion on the courts is kind of lost in the discussion of the laws and all the constitutional amendments. So if I was looking at this paper, if I was sort of thinking what would be a great singular objective of the paper, it would be to look at all of the maneuvers, counter maneuvers, re-maneuvers that have been done by the courts, the executive, in responding to each other as they kind of go through this policing of preventative detention. That to me was the most interesting starting point, or the most interesting thread, or perhaps the most developed thread that came across in the paper. So that's just more on construction, objective, and really clarifying and teasing out the main objective of the paper. The second comment I had was whether there needs to be, and this kind of resonates with something Arudra was saying, a stronger periodization in the paper. So for example, when you're looking at preventative detention, you're looking at preventative detention sort of simpliciter, and then you're looking at preventative detention appearances when you're in the context of the war against terror. To me, they raise very different questions, very different balances, very different calls for accountability, transparency of decision-making, and need for control with respect to the executive. So I felt like there wasn't enough of a distinction made between the work of the military and the executive in those two different areas. So I'm just gonna pause there because I see some questions coming up. And if after those questions there's still time, I'll come back to my remaining questions. Ronak, I have Ronak and then Surabhi. So I'll go with Ronak first. Okay, Ronak, Surabhi, maybe you can go first.
Sure, I'll try and keep it brief. I wanted to echo, sort of pick up on a couple of things that Arudra, you had said. I completely agree that I thought the whole rule of law thing was a bit of a red herring, because I think then as the reader, you're looking for that to be developed, and it isn't. And I say this as someone who isn't a rule of law scholar, isn't a legal philosophy person. My very sort of uneducated in terms of, you know, the rule of law theory, my response was, well, was there liberal rule of law? Because a lot of what you're discussing is authoritarian regimes and courts adjudicating these cases under authoritarian constitutions, right? Constitutions that sometimes didn't have bills of rights, or bills of rights being suspended, etc. So I thought it was a red herring. On the context point, Tarun, that you raised, I agree. I think political context is very skillfully woven through, but I think in the letting the paper breathe, I think one of the things we need is, however you periodize it, I think we need, maybe at the end of each section, a little bit of hand-holding for the reader, reminding us why what the court did was bold and interesting given the specific political context of that period. Or, you know, perhaps not bold, but strategic and cautious but canny, or whatever it is. I think we need a little bit more guiding us through, because otherwise we get lost in the details. On the judicial strategy, judicial tactics, so something that I was curious about, and this picks up on Arudra's curiosity about some of the cases, like just wanting a little bit more, you know, what was going on here. I was worried. I mean, the paper is structured, I think, in the material, the sort of archive of material delving into. You're looking at sort of a jugalbandi, right? The executive branch, the military regime, or the democratically elected executive, and the courts. I started to wonder about the petitioners, and were there kind of repeat, you know, was some of this strategic litigation, the kind of very deliberate, considered testing of the boundaries? So I wondered about that. There might not be space to put that in, but I was very curious about it. And I think in talking about judicial tactics, one small point, I wondered about timing. When the points at which the judiciary was bold, was it when they could, was it when support for a particular regime was waning? Because you know, the judges are political actors and politically sensitive actors. So I wondered about that. But I also would encourage sort of not thinking about it purely as judicial, as sort of tactical maneuvers, but also thinking about judicial culture more fundamentally. And I mean, talking about culture is always problematic, but you know what I mean. Are there principles, are there ways the judiciary seems to construct itself that guide its rhetoric and its thinking alongside the political caution, the strategizing, the tactics? So just the sort of think about what the judiciary is doing at different levels. And with just coming back to rule of law, I started to wonder, is liberal rule of law important rhetorically to the judiciary in doing what it does through all of these years that you traverse in your paper, right? And is that the work that rule of law is doing? Is that why it sort of stayed with you as something you need to talk about? Is it important to the judiciary, even as kind of political cover when it is breaking with the executive branch and not being acquiescent? So I agree that I don't think it should be the frame of the paper, but I wondered what work it was doing in structuring the judiciary's thinking and what work it was doing, that concept, in protecting the judiciary. And that actually was not short at all. So apologies, Swati.
That's all right. Thank you. So I have 4 people on our list. So I will ask if questions could be short and brief so we can just capture everyone's questions. So Ronak, I have you next. And you're on mute, Ronak. Yeah.
Can you hear me?
Yes.
Thank you so much for taking the question, and thank you so much for organizing this amazing initiative. It's the first time I am actually participating verbally in this. I've been listening to it on site. And I read your paper, Professor Aziz, and it struck to me how we are talking about rule of law. And it made me question that Albert Wayne Dicey, the famous Oxford professor, he came out with the whole notion of rule of law in his book. And he mentions, and it's very important for me to mention this here, that there's no such thing as martial law. England doesn't know any concept of martial law. Albert Dicey, the person who coined the term rule of law, and he is very vehemently denying that martial law exists. At that point of time, India had witnessed martial law. The West Indies, which was also a former colony of the British, it had also witnessed martial law. South Africa had gone through martial law. And to this day, it strikes me very odd. It's extremely odd that Dicey is denying that martial law as a theory or as a doctrine is existing outside England. Having said that, I would a lot has already been said by everyone here about the conceptual framework, about devising the conceptual framework of the paper. And after reading your paper, it's a little not clear to me, like what notion of rule of law that you are trying to follow. Is it like the procedural notion which is being propounded by Professor Joseph Raz and Judith Shaklar, or the substantive notion of rule of law like propounded by Professor Justice Bingham, or is it like the teleological notion of rule of law which is being put forward by Professor Martin Kraiger? You cite Professor Kraiger's paper, but there's this notion of like teleology that is missing from it. You're saying it's tempering rule of law, versus what he means by tempering is like you have to say what is the end purpose of rule of law, whether it's a thin form of rule of law, whether it's a thick form of rule of law. So it's little unclear for me at that point of time. Thank you.
Thanks, Ronak. Okay, so I have Dinesha next.
Thanks, Swati. Moeen and Sadaf, thank you very much for your paper. I must say I enjoyed reading it this is not the kind of paper you enjoy reading. It's about detention and missing persons, but it was good to read a paper in this region other than from Sri Lanka or Nepal, which talks about some of these issues, and of course India. So in that sense, I think the final paper would make a distinct contribution to literature in this region on these two issues.
So I read the paper as it stands now as giving me a bird's eye view of what has happened in these different cases. But as was mentioned earlier, I was wanting to know what the takeaway would be. So if when you revise it, if you make your scope clear and also tell the reader what you're leaving out, in addition to signposting, that would be very useful. So in that, I was wondering the connection that you make between detention and missing persons in terms of judicial review and criminal justice, whether you can make it clear, because one could argue that those are two very different categories which require different framing because of the impact, the difference in impact, so to speak. And this last point I wanted to make was about the judiciary and whether if we are looking at missing persons and preventative detention from the perspective of how this impacts individuals and society, what is it that we learn by studying the judiciary? Because one could also make the case that it's so contingent that it's very hard to make connections across the time period that you study in order to offer something clear to the reader about how this legal system is operating in relation to individuals. In some ways, it's the so what question from access to justice point of view or from a victim point of view. I'll leave it there. Thank you.
Thanks, Tanisha. So I have Puranjoy and Arudra. Puranjoy, I think, is having difficulties connecting at the moment. So Arudra, I'll go to you.
Oh, it's just a suggestion following up on Surabhi's point that it may be interesting to look at potential litigants. And just to say, I don't know if there are civil liberties histories in Pakistan, but that might be one place to look. Certainly, I've been doing this work now in the Indian context in the 40s and 50s. And it's quite interesting to see, there's a legal literature on habeas corpus, for instance, and then there's maybe a political history on civil liberties activism, neither of which speaks to each other, but in fact, you see them intersect and they're talking about the same cases. So that might be a place where, and by the way, one of the things that goes back to maybe this term rule of law is we're using too much, but it's quite interesting to see how, at least in the late 40s and the early 50s in India, the civil liberties activists are really just saying the high courts have saved us, and what saved us is, essentially, I think, principles of legality. So yeah, that's it.
Thanks, Rudra. Puranjoy, are you able to ask your question? Okay, so maybe while Puranjoy is connecting, I had just a quick sort of further two thoughts. One was something I picked up on, I think, okay, page 3. Let me just grab, sorry, just give me a moment to get to the relevant. So, okay, so there's something in your paper where you talk about the roots of authoritarianism. I think it's paragraph 3 at page 13. I'm just trying to grab it, please. Okay, so I can't find exactly where in the paper I was provoked by this thought, but the idea was that I wanted to know a little bit more about what was exceptional about the doctrinal jurisprudence coming out of the Pakistan courts, because a lot of the conversation that you're having in describing the cases is comments I've heard from judiciaries around the world when they're dealing with national security in the courtroom. So the idea of the kind of balances that they're striking, the fact that they let the higher political executive off the hook and focus their attention on the bureaucracy and the police instead in the context of administrative law, and not really having the site of contestation being the Constitution, but sort of downstreaming the site of contestation to really the bureaucratic level. This is something that I think you could say was true about most common law courts dealing with the whole war on terror as a matter of jurisprudence. So what I was really interested in understanding a little bit more from your discussion of the cases is, where's the exception, sort of the really Pakistan-specific jurisprudential points that are coming out of the cases when they're interacting with all of this legislation and all of the phenomenon that is being litigated in the courts. So I think bringing that out a little bit more will accent the kind of dilemma that your courts are facing in maneuvering with the executive to really flesh that out a little bit more. So the second one, I just want to kind of continue with the point I was making earlier about the sort of separating out timeline-wise, the different bits of the different periods of detention and disappearances. So really looking at how the courts have had to change their approach and change their strategy. And it connects to something Surabhi was saying about understanding a little bit more what litigants were doing at different points in time with the court. So I'm really a little bit more interested in wanting to know who these litigants are. So somewhere in the paper, you mentioned that there was a lot of opposition politicians that were getting involved in kind of nudging habeas corpus writs before the courts. So I think bringing out a little bit more how the litigation strategies were also changing would be an interesting story. So for me, I'm really interested in that court paper that I hope is sort of an output of this paper. So not just looking at the executive and government maneuvers in response to the courts and the courts maneuvers in response to the government, but also looking at litigants maneuvers all in the background of what's happening. So again, to me, that would bring out a little bit more what's specifically happening in the context of detention and disappearances in Pakistan that's different from Nepal, Sri Lanka, India, for example, within the region, and also what's distinct about it in Pakistan as opposed to what's happening in just generally in the world when we're talking about the war on terror. So that's all I have on my list, but I do, again, I'm very bad at multitasking, so people's comments are coming in on chat. So, okay, next I've got Renuka on the list.
Hi, Moeen and Sadaf. Thank you so much for your paper. Really fascinating. I'm from Malaysia, junior faculty there, and lots and lots of parallels with your jurisprudence and ours. So the thing that I found really interesting was how your FBLE case, and then the cases which talked about how the courts are prepared to take a thin rule of law approach. And then, so all those types of cases we also have. And the point I wanted to make here was I can relate to your need to rely on the rule of law because so I did a piece on immigration detention, which to a large extent has also got a lot to do with executive discretion. And in doing so, and looking at constitutional protections, I also found that the only thing I could fall back on was the right to life, the right to liberty provision in the Constitution. And then at the end of the day, I was trying to, I really struggled to try to come up with a sort of a justification for what's the foundation of my argument supposed to be. And I also fell back on the rule of law because there really wasn't anything else to fall back on. I couldn't rely on any international law. Malaysia has not signed on to a lot of international, none of the, for example, the ICCPR and all of that, it's not signed on to. And in trying to make an argument that, for example, the government, the executive or the judiciary, the very executive-friendly judiciary would buy, I too fell back on the rule of law. So I feel that, for what it's worth, it's something it's worth relying on for that reason. That's my comment. Thanks.
Thanks, Renuka. And I found the point in the paper that I was wanting to refer to. It's the start of the last full paragraph on page 3, which starts, "Such was the contradictory tradition of authoritarian rule of law." You have a phrase there which says "near impunity in the exercise of preventative detention at the levels of the higher executive, tempered by the court's procedural and ultra vires review at the lower levels." So I could lift that paragraph and utilize it to talk about Hong Kong, for example, or Singapore, or even the UK. So that's really where I was prompted to think, well, I want to know what's specific to Pakistan when it comes to this final health assessment of the courts. Okay, Swati, I have you next.
Yes, hello. So thank you for the wonderful paper. I'm working on a paper on enforced disappearances in Kashmir. So I am personally interested in knowing from the authors that what actually was the literature that helped you build these arguments. So it's a tightly packed paper. So what literatures did you give primacy to?
And I guess if I could just connect to add to Swati's comment. So I'm going back to the paper that I'm really pushing on you now, which is the paper about the courts. I guess, so rule of law to me is, so I hear Renuka's comment in the context of Malaysia. And whether that might be the right, whether that still is a frame worth holding on to. And I hear what Surabhi was saying, whether the reason rule of law first appeared on your horizon was because the courts might have been using it for strategic reasons within their rhetoric. So maybe there is still something to explore when it comes to the rule of law. But on the assumption that, okay, we're not utilizing the rule of law, I think when sizing up the role of the courts, what is the literature that you would be utilizing to decide on your normative base point for where you want the courts to land off? So do you want the courts to have this incremental role? Realistically, is that what you're kind of resigned to accept in the Pakistan context? And how do you kind of make sense of that from a more normative perspective? How do you rationalize that as a role for the courts within the sort of authoritarian context in which they're operating? So I think there is still a need to, and Swati, this will maybe help with your paper in the context of Kashmir, but just what is the theoretical literature that you're dialoguing with when really sizing the courts up? So it's connected to Swati's question, but I'm interested not as a person who's writing the paper, but more just interested in what will be utilized, if not the rule of law, which I think is maybe not the best tool, but what would be the theoretical tool that's utilized? And then I have Tarun next.
Thanks, Swati. So this is actually directly connected with, actually not, I'm trying to connect a few dots. I think one of the discussants, I suspect it was Surabhi, asked a question about, or was it Arudra, the emotional sort of feel. They had a much more eloquent word for this, the emotional temperature in the cases, in terms of its rhetoric and its expressive salience. Connecting that to Swati's pressure on what is distinctive about this, to Renuka's worry about Malaysia and Yvonne's work, and looking at all of that in terms of Moeen's earlier paper on Islamization, and how, for those who have not seen Moeen's excellent earlier paper, how the Pakistani courts start using Islam in the constitution to buttress liberal ideas, right? So finding, if I'm getting this correctly, Moeen, obviously you're the author, and I would have said, you can correct me, but you can't, because our format is that authors just take comments and don't reply. So what would be really interesting, and maybe this is a second paper because this paper is great as it is to think about whether that has happened on civil liberties as well, whether there is an alternative legitimacy seeking move. It could be strategic, it could be sincere, who cares, right? What would be interesting is to see whether the judiciary is finding additional support for, say, habeas corpus in Islamic jurisprudence or not, right? Because I think the negative is also interesting, because it's finding so much of finding so much of liberal ideas in Islamic jurisprudence in other areas. Why is it not reaching out to Islamic jurisprudence in civil liberties? And if it is, that story would also be a fascinating news story to tell the world, and I think would be really helpful addition to the literature. And there, I think the rule of law will be very interesting as a discussion point. And a brief comment, because we hold these workshops not just for the benefit of the authors, right? We're also trying to learn in a community, how to be a discussant, how to chair, how to give comments. I just want to, point out, and sometimes these things are just useful to not just show, but also tell. So point out to the participants just what a model set of discussants and, the chair when giving her comments have been, right? Because we have always said the one rule for participation and asking questions is that, ask yourself what your motivation is. If you're trying to ask a question to show how clever you are, then don't ask it, right? Only ask a question if it'll help the authors. So I think our discussants and chair, and most of you have been sort of absolutely model participants for a workshop in that sense. And I just wanted to acknowledge that before giving it back to the chair. Thank you.
Thanks so much, Tarun. So I think we're gonna wrap up now. Sadaf and Moeen, I hope you found this helpful. I don't want to put on this immense burden to absorb and respond to everything that everyone has said in a super eloquent 2 minutes. But just, I really hope that you found this helpful. I've been keeping a note of all the questions and discussions that have been going. So if you find that there's a gap in your notes or just want to pick up on something, please do feel free to get in touch. But I'd really like to thank Surabhi and Arudra for their comments and for just kickstarting a great discussion with a lot of provocations for the authors. I'd like to thank the authors as well for so generously sharing your paper at this stage of its development. We really look forward to seeing how it develops. And I speak for myself, and I'm sure many people here, that everyone would be just interested in keeping in touch with you on your paper. And yeah, happy to read any future drafts. And thank you also to everyone who posed questions. I see Moeen, I see your little finger going up. So I'll continue. But really, yeah, thank you to everyone from the floor as well. And I guess, Moeen, you get the last word.
No, I understand that's not the format, but there was something that was personally really fascinating for me. And as I said right at the outset, totally take the point amongst so many other like wonderful comments that rule of law theory is not the right framing for it. But I can't help but respond to Rudra's point. And I think Surabhi also like mentioned that in her later comments is the fascinating thing is Pakistan has gone through multiple regime times. And one can get lost in telling that story. There's been a very fascinating story about judicial power waxing and waning, and one can again get lost in that story. But if one were to to some extent oversimplify it, the most fascinating bit about that story is, for much of Pakistan's history, not the recent one, but especially in the earlier periods, they may have been constitutions, but Pakistan was effectively under emergency rule in one form or another, whether it's direct martial law, whether it's constitutional suspension of of the constitution for a long part of that history. And what these courts did again and again, and this is what I'm, because I was really fascinated by Joe's comments, is what they did was they went back to that point, is that even in the absence of formal constitutionalism, when the constitution is under suspension or there's emergency, there's still a bedrock of rule of law. So if the courts are in business, their core business is to do the rule of law. And again, whether it's Islamic legality or whether some concept of the rule of law, that's where that was kind of like the minimalist constitutionalism in the absence of a constitution. So maybe that's the story we should be foregrounding if we talk about the rule of law, as opposed to getting involved in really messy business of rule of law theory. That's all I'm going to say.
No, thanks, Moeen. Actually, the way you ended off is quite important for the forum, actually, which is the whole point with the forum is to really figure out, is to expose your paper structure as well, and expose the whole point of emphasis of your paper, and to see whether people share your point of emphasis. So I think you really kind of highlighted what for me is like a real advantage of the forum. It's something we don't really think about sometimes when we're writing our paper. We get so caught up in content and making sure we cover the right content, and maybe not enough, we just don't have then the bandwidth to start thinking about emphasis, structure, and organization. So yeah, thank you for that comment. I see, so I'm very conscious of time and how late it is for some people. So I'm gonna wrap it up here. We have been recording this, and the recording will be posted up on Twitter as well. So Sadaf, Moeen, that's another way to just catch up on comments that you might have missed, but really do get in touch if there's anything I can help with from my notes. So with that, just thank you very much to everyone for being a part of this. And we really hope you'll be joining us for future sessions.
Thank you.
Thank you.
Bye.
Thank you. Bye-bye.
Bye.